This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're talking about why real property damage is required if one seeks a defense under a CGL, and property damage must be actual, not potential. And a breach of a construction contract is never an insured against peril. After the plaintiff's motion for summary judgment was rejected and the defendant insurer's motion for summary judgment was granted, the plaintiff appealed in Westchester Modular Homes of Fairfield County, Inc. versus Arbella Protection Insurance Company. The Court of Appeals of Connecticut on April 2, 2024 resolved the dispute. On or about April 27, 2016, the plaintiffs entered into a contract with Diana Lada and Jacques for the construction of a new modular home on property located in New Canaan, Connecticut. During construction, disputes arose between the Hnaffs and the plaintiff. Ultimately, the Hnaffs terminated their contract with the plaintiff on December 14, 2016. The plaintiff filed a mechanic's lien on the property on or about February 3, 2017, and commenced an action to foreclose on the lien on or about April 7, 2017. This was called the underlying litigation. The Hnaffs filed a counterclaim that alleged that they desired to build a modern home and had very carefully and specifically specified the types of insulation, materials, and finishes that they required the builder that won the job to satisfy. The Hnaffs alleged that the work on the project progressed slowly and with constant problems. The Hnaffs alleged that the plaintiff had breached the construction contract. The plaintiff is a named insured under a commercial general liability policy issued by the defendant, filed a claim for coverage with the defendant, which was refused. The defendant insurer disclaimed coverage on the basis that the first revised counterclaim filed in the underlying litigation did not allege property damage caused by an occurrence, and therefore it did not trigger coverage under the policy. The trial court determined that the pleadings in the underlying litigation did not allege property damage. As to the extrinsic documents submitted to the defendant by the plaintiff, the court determined that such evidence established only the existence of possible defective work that could lead to future property damage if not remedied, but that it did not demonstrate the existence of current property damage. The Court of Appeal noted that because there were no factual issues in dispute, the court was only faced with the legal question whether the defendant had a duty to defend the plaintiff. Specifically, the defendant contended that the extrinsic documents suggested at most that the construction deficiencies could potentially result in water damage to non-defective areas of the property if not fixed. The plaintiffs alleged construction defects and did not allege damage that the defects caused to other than the defective property, since the plaintiff's expert testified that he had identified defective work that, if not remedied, could lead to property damage in the future, but identified no damage. Plaintiff failed to allege facts bringing the underlying litigation seeking property damage that could have required a defense. The Court of Appeals made clear that repairs to structural deficiencies made for the purpose of preventing physical injury to tangible property before the alleged deficiency had caused property damage are not within the insuring agreement's definition of property damage. Because there is no indication of water damage at all. At most, the construction deficiencies could potentially result in water damage to non-defective areas of the property if not fixed. Damage to non-defective property in the form of rot or mold caused by water intrusion would be property damage within the terms of the policy language if it existed. However, the plaintiff did not present any evidence of actual damage or case law holding that the presence of water in the absence of actual damage amounts to covered physical damage. The Court of Appeals concluded, therefore, that the notification of the mere presence of water without some corresponding physical damage did not provide the defendant with actual knowledge of facts establishing a reasonable possibility of coverage, because the presence of water alone does not constitute property damage within the terms of the policy. Accordingly, the defendant did not have a duty to defend the plaintiff in the underlying litigation, and the court properly rendered summary judgment in favor of the defendant and was affirmed by the Court of Appeal. In my opinion, when an insured breaches the terms of a construction contract, it will invariably be sued by the other party to the contract for damages resulting from the breach. Westchester Modular Homes breached its contract by creating defective modular home that would, in the future, if defects were not cured, suffer physical damage. Since there was no physical damage to the structure, just the potential of damage, coverage did not apply, and Westchester was obligated to defend and indemnify itself from its own assets to the allegations of the underlying litigation. Obviously, not everything is covered by an insurance policy, and that is why risk management is also required, and one must pay for his own errors when you create a defective dwelling. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com. And you can subscribe to the blog, and you'll receive notice of every blog posting, usually 5, sometimes 6 a week. And you'll also gain access to the more than 4,750 blog postings. You can similarly subscribe to the videos on YouTube and rumble.com. They're free. And if you do, I'd appreciate it if you click on the like button on YouTube or the thumbs up button on rumble.com. And I'd appreciate it if you tell your friends and colleagues about this blog and the videos so that they too can subscribe. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud for a very small fee of $5 a month, you can subscribe to my Substack publication. Thank you for your attention.